Hello, everyone. I'm Jennifer Hill, Director of the Centre for Commercial Law and Regulatory Studies, and it's my great pleasure to introduce today's seminar. We have Dr. Takuma Kumashiro, who is visiting CLARS at the moment from Kobe University in Japan. He is a specialist in ESG and corporate law, and today he's going to be speaking to us on the topic Guardians of Truth, ESG disclosure accuracy. So we're very fortunate. We have him here for 3 months. We've been enjoying having him amongst us over the last few weeks. And after he stays with us for 3 months, he'll be going for a year, I understand, to Oxford University. So I'm going to pass over at this point to you, Professor Kumashiro. Thank you.
So thank you for introducing me, and thank you very much for giving me this opportunity to present my research. I have been at Monash University as a visiting researcher since February, and will be staying until the end of at the late of August.
Oh,
yeah. So no problem. Yeah, and I'm truly enjoying my time here. And that is entirely due to warm welcome from the Monash people, especially Jennifer, Tamara, Duncan, and Steve, many people. I'd like to express my deepest gratitude to them once again. Today, I'd like to present my research titled Guardian of Truth, which explores the legal enforcement of ESG disclosure accuracy. This paper is deeply important to me. It serves as a bridge between me and Jennifer and Monash University, following the insightful comments she provided at symposium in Bangkok last year. On personal note, it has been about 10 years since I entered into my master course. While I have written one monograph and about 40 papers in that time.
40?
40, yeah.
Some people would be.
But every single one of them has been written in Japanese until now. So this is my very first English paper. So it's a significant milestone for me. I can only hope it proves more engaging than a dry audit report. Doesn't move.
Not going down?
Not going down.
We're just talking about tech disaster.
Okay.
I think I can give you that. Yeah.
Thanks so much.
Sorry, it's very long.
Some places.
No problem. Okay. So, to appreciate how we arrived at this moment, it helps to situate mandatory disclosure within the longer arc of ESG history, which scholarship divided into 3 distinct waves. The first wave from the mid-1970s to the 1970s was driven intergovernmental institutions. The key document was OECD guidelines for multinational enterprise adopted in 1976. Interestingly, the same year, so Jensen and Meckering's agency papers, agency series papers, and Eisenberg's structural analysis of the corporation, and Nada, Green, and Seligman's critical of mega corporation. In other words, 1976 was the year in which the modern debate about corporate purpose, shareholder primacy versus multi-stakeholder approaches were stimulously born. Even then, ESG was entangled with the deepest question in corporate law. The second wave from the 1990s to the mid-2000s was largely voluntary. Companies and NGO developed a framework to support discretionary disclosure. The emphasis was on reputation, not legal compliance. The third wave, after the global financial crisis of 2007 to 2008, regulators worldwide concluded that voluntary disclosure was insufficient. They began mandating or actively promoting ESG disclosure as a part of a broader framework for corporate transparency. Both Japan and Australia are in third wave jurisdictions, but they arrived there with delay and through different institutional pathways. Japan's story is particularly interesting. ESG disclosure in Japan has been driven not only by environmental or social concern, but by economic growth strategy. After 10, after some, after the long decade of stagnation, improving corporate profitability and attracting foreign institutional investors become a policy imperatives. The Stewardship Code and the Corporate Governance Code of the 2014 and 2015 and the GPIF adoptions the ESG indices and in 2017 were pivotal moments. Japan's 2023 amendment to the annual securities report, including a dedicated sustainability section, is the latest milestone in this trajectory. For its part, Australia has recently enacted mandatory climate-related disclosure requirements under the Treasury Laws Amendment Act 2024, aligned with ISSB standards. Like Japan, it has arrived mandatory disclosure after a period of voluntary framework. This creates a central puzzle. ESG information is fundamentally different from financial information. Financial data, for example, revenue, profit, liabilities, is largely quantitative, backward-looking, and auditable. However, ESG information is often qualitative, forward-looking, and discretionary. Scholars have characterized it as having a credence quality, meaning its accuracy is inherently difficult to verify, even for sophisticated gatekeepers, because of complexity of underlying methodologies. This creates a dangerous gap. Regulators have built elaborate mandatory disclosure regimes, but the enforcement infrastructure originally designed for financial information struggled to adapt. So my research question is for this: how can public and private enforcement mechanisms and ex-ante and ex-post approaches be effectively structured to ensure the accuracy of ESG information while striking appropriate balance among investor protection, stakeholder transparency, and compliance costs? Before analyzing the specific mechanism, I'd like to establish the theoretical foundation. Why does accuracy in ESG disclosure matter in the first place? I identify three distinct rationales, which I call theories, and each implies a different enforcement logics. The first one is the investment decision theory. Under this classic securities law framework, mandatory disclosure resolves the information asymmetry between companies and investors. Accurate ESG information allows investors, particularly diversified institutional investors, to assess systematic risks, such as climate change and pandemic exposure, that cannot be eliminated through portfolio diversification. ESG disclosure on this count is a complement to traditional financial disclosure. It enables more efficient capital allocation and protects investors from securities fraud. The second is the corporate governance theory. Here, the emphasis shifts from the market to the boardroom. Accurate ESG disclosure creates accountability. It incentivizes directors to gather relevant information proactively and to build robust internal control system. And the last one is stakeholder accountability theory. This is the most ambitious rationale, and it is one of the most clearly embedded in the EU's approach. The argument is that ESG disclosure can motivate companies to address ESG challenges, not merely to report on them, by enabling external pressure from non-shareholder stakeholders, for example, consumers, business partners, local communities, and NGOs. This theory underlies the concept of double materiality. Companies should disclose not only what ESG factors mean for their financial performance outside in, but also what their operation mean for society and the environment. So that is inside out. These three theories are not mutually exclusive, but they have different implications for who should pay accuracy assurance and what mechanisms are most appropriate. Critically, the first theory can be solved by a private market mechanism. The third theory likely requires public enforcement with a broader mandate. With these rationales in mind, I now introduce the organizing framework of this paper. Enforcement mechanism can be mapped along two dimensions, exposed based on timing and actor. Ex ante is a before disclosure versus ex post, and public versus private. For example, as we discussed later, third-party assurance as introduced a recent amendment of the Companies Act, Australian Companies Act, is a third-party assurance is posited as the ex-ante private mechanism, and civil liability of the companies or directors posited as the ex-post and private mechanism. So this framework generates 4 quadrants, and each real-world jurisdiction do not operate from a single quadrant. Every jurisdiction, every system involves some combination of tools, but each major jurisdiction has a characteristic center of gravity, a dominant approach around which other mechanisms are organized. I'd like to examine the United States and the EU model in turn. The United States model is ex post private led. It's rely on investor-driven securities fraud litigation under Section 10B of the Security Exchange Act of 1934 and Rule 10b-5. The strength of this model is its deterrence. The credible threat of the class action litigation provides a powerful incentive for companies and its directors to ensure the accuracy of their disclosures. And unlike public enforcement, it does not require government resources to initiate. But the limitations are severe, and they are particularly acute for ESG information. A plaintiff under Rule 10b-5 prove 6 elements: a material misrepresentation or omission, scienter, a connection to securities transaction, reliance, economic loss, and loss causation. For ESG disclosures, this is formidably difficult. On materiality, many ESG statements are classified as purely aspirational language too general to induce reasonable investor reliance and dismissed at the pleading stage. On scienter, proving intent or reckless disregard for the truth is especially challenging where the ESG estimate involves genuine methodology uncertainty. On reliance, fraud on the market doctrine applies, but the causal chain between ESG misstatement and the market price movement is often tenuous. The result is structural tension. The threat of litigation deters frivolous greenwashing, but it also deters legitimate disclosure. Companies fearing that the forward-looking ESG statement will expose them to litigation become systematically conservative. This is a phenomenon I call disclosure seal, and it directly undermines the mandatory disclosure regimes regulators have worked so hard to build. There's a further point analytically crucial. ESG information disclosed for the benefit of other stakeholders than investors. For instance, disclosure about environmental externalities or human rights due diligence may simply fall outside the scope of securities fraud enforcement. Securities law protects just only investors. So in the ordinary course, it does not protect the communities, workers, or ecosystems. The European Union has taken a different approach through the CSRD, which mandates third-party assurance sustainability information. This is a proactive ex-ante mechanism. By requiring independent verification before disclosure reaches the market, it prevents false information from distorting investment decisions and public trust. But here are 2 limitations on the significant. First, the scope of verifiable information is narrow. Third-party assurance works best for objectively quantifiable metrics, particularly greenhouse gas emissions. The qualitative, forward-looking, and discretionary dimension of ESG information are either excluded from assurance or verified only for compliance with reporting framework rather than substantial accuracy. Second, qualified providers are scarce. ESG assurance services have grown primarily in the consulting arms of the big four accounting firms. This creates potential conflicts of interest. The same firms advising companies on ESG strategy are also assuring their ESG disclosures. Many jurisdictions have introduced independence requirements, but these further restrict the supply of eligible providers. The third, the costs are substantial. Mandating assurance for all companies above a certain threshold imposes compliance costs regardless of whether a company has engaged in any misrepresentation. And as Enriquez, Roman, and Tuck have added, the reputational mechanisms that normally discipline gatekeepers are weak in the ESG assurance market because users have limited incentives and abilities to verify whether certifications are accurate. The warm glow effect, the psychological comfort of believing a company is sustainable, can suppress legal scrutiny. There is also a cost allocation problem with deeper normative implications. The company bears the cost of assurance, which is ultimately passed on to shareholders. But if ESG disclosures serves not only investors but also broader society, why should shareholders alone bear the cost of assurance infrastructure? So Japan's case is both the most detailed empirical contribution of this paper and the most diagnostically revealing. It demonstrates what happens when a jurisdiction falls primarily into the ex post and public quadrant without adequate resources or institutional capacity. A distinct feature of Japan is that the ESG information is disclosed across three separate mandatory documents, each governed by different legislation and each subject to different enforcement mechanisms. The first is a business report, governed by the Companies Act. Here, the accuracy assurance mechanism are relatively well developed at the ex-ante stage. The report must be approved by the board of directors and audited by the Kansai. It's a unique Japanese audit system. On the ex post side, directors may face administrative sanctions fees if the report contains a misstatement and civil liability under the Companies Act with a reserved burden of proof. And where the business report has been presented at a general shareholder meeting, shareholders may seek a decision of the relevant resolution. The second document is an annual securities report governed by the Financial Instruments and Exchange Act. It's similar to Securities Exchange Act 1984. This is the most heavily enforced of the three. The Financial Service Agency and the SESC exercise ongoing supervisory oversight. Material misstatement may trigger administrative fines as well as criminal liability for officers. Civil liability is available to investors again with reverse the burden of proof. And the Tokyo Stock Exchange may impose listing management measures, including designation as a security on alert or delisting. On the extent side for the annual securities report, my table currently shows the third-party assurance as absent. That remains a position under current law, but I should flag an important recent development. In January of this year, a working group established under the FSA released a draft amendment to current act. The proposal would introduce the mandatory third-party assurance for limited subset of ESG information in annual securities report. The scope is narrow, but it represents the first concrete legislative movement toward ex-ante private assurance in Japan. The third document is the corporate governance report governed listing rules. The enforcement picture here is thin. The only dedicated mechanism is exchange level sanctions. So what this mapping reveals is not a rational designed system. It is a path-dependent accumulation. Each statute prescribes its own mechanism independently with no coordination across the three documents and no overreaching design logic. The result is very simple, fragmentation. The gaps where no mechanism applies, inconsistency in the burden of proof of across documents. And most importantly, systematic under-enforcement, particularly for environmental and social information, fall outside the traditional governance focus of Japanese securities litigation. To understand how ex-post enforcement actually operates in Japan, I examined all publicly available enforcement actions in which a misrepresentation or omission of ESG information in annual securities report was at issue. The result, just only 8 cases over the entire period for which data is available. Of these, 6 result in administrative fines imposed by the FSA financial service agencies, and 1 resulted in both administrative fines and civil liability. It's the first one, Save Railway case, and 1 resulted in criminal liability for corporation and its executive director. It's a Nissan Motor case. It's a fourth one. What information was at stake looking at the pattern across cases, related party transaction in 3 cases, and corporate governance information, especially board composition or executive director's remuneration in 2 cases, information on major shareholders or stock option allottees for Yakuza in 2 cases, and MD&A in 1 case. The crucial observation is this: in every case, misrepresented or omitted information are pertained to governance, not to environment or social factors. There has not been a single publicly known enforcement action in Japan for misstatement E or S information. Why? The answer lies in institutional capacity. Securities Exchange Surveillance Commission, SESC, is the primary enforcement body responsible for inspecting those disclosure documents. It was fewer than 400 staff in total. Its disclosure inspection division, specifically responsible for reviewing annual securities report, has an estimated few dozen to perhaps 100 officers. Against this, Japan has approximately 4,000 listed companies, and roughly 2,700 of these have a March fiscal year end, meaning their annual securities reports are submitted within a compressed window of a few months. So the comprehensive review is impossible. SESC operates on a risk-based selective review model, and even then issues fewer than 10 recommendations for disclosure violation per year across all categories, not just ESG. Compounding this, when investigations do occur, they tend to be triggered by financial misstatement, and ESG misstatement, when detected, are typically discovered instantly. The 4 cases involving financial misstatement alongside ESG misrepresentation support this reading. Let me highlight 2 cases that illustrate what falls through the cracks of this system. The first one is a TEPCO case. In June 2010, Tokyo Electric Power Company filed an annual securities report describing its progress in seismic reinforcement measures at its nuclear power plants, including Fukushima Daiichi. In March 2011, the Great East Japan earthquake triggered a tsunami that caused the complete collapse of power at that plant, leading to one of the worst nuclear disasters in history. Subsequent litigation about the directors of fiduciary duty established that TEPCO's directors had prior knowledge of the flood risk. This suggests that companies' disclosure about earthquake and flood preparedness disclosure of the direct relevance to both investors and the public were materially misleading. No enforcement action was taken for these disclosure failures. The second case is a Fuji Media Holding case. In June 2024, Fuji TV's parent company, Fuji Media Holdings, disclosed a commitment in its annual securities report to ensuring safe working conditions for employees and collaborators, backed by a group human rights policy established in November 2023. It was subsequently revealed that a prominent performer had committed sexual assault against employees and that the company had sought to handle the matter covertly. The independent investigation report was published in March 2025. Again, no public or private enforcement action has been taken for these potential misstatements in social information. These cases are not exceptional. They illustrate a systemic pattern. ESG disclosure, particularly E&S disclosures, are not systematically reviewed, and inaccuracies go undetected and enforced. Let me now draw together Japan's distinct characters, fragmented, path-dependent enforcement with now an unified approach across disclosure documents, a governance-centric enforcement, heavily reliance on exposed public enforcement, and virtually absent private enforcement, no class actions, limited shareholder inspection rights, high litigation costs with few mechanisms to reduce or fund them, and reactive and ad hoc public enforcement rather than proactive or systematic oversight. Japan is not alone in facing these challenges, but it presents pathologies in usual clearly. My central argument is that the failure I have described are not incidental. They reflect the fundamental unsuitability of any single enforcement mechanism for the full range of the ESG disclosure challenges. Ex-post private enforcement is a securities litigation in the United States is powerful but narrow. It requires proof of financial harm. It creates disclosure seal, and it cannot reach information relevant to stakeholders other than investors. Ex-ante and private enforcement, such as third-party assurance in the European Union, is proactive but constrained. It works for quantifiable metrics. It is costly. Qualified providers are scarce, and reputational discipline is weak. Ex-post public enforcement, as I shown, Japan as administrative action in Japan, has the broadest coverage in theory, but it requires resources that regulators do not have. In practice, it produces reactive, financial-focused enforcement, and that leaves E&S information systematically unprotected. The solution, I argue, is not to choose between these mechanisms, but to strategically allocate them based on their comparative advantages. I call this a hybrid model, and it has three core components. The first component is third-party assurance should not be mandated across all ESG information indiscriminately. Such an approach would generate enormous compliance costs with limited marginal benefits, particularly for qualitative and discretionary disclosures. And the second component addresses the problem disclosure seal. The ceiling effect that overbroad private or liability imposes on the disclosure. The solution is not to abandon private liability, but to recalibrate the materiality standard to reflect distinct character of ESG information. Under the current United States doctrine, ESG statements frequently dismissed as immaterial because courts apply material tests calibrated to financial information. This test is poorly suited to qualitative forward-looking ESG disclosures. So I propose materiality for ESG purpose be assessed in a context-specific manner, taking into account the nature of the information, investor audience, and breadth of the stakeholders' interests that disclosure is designed to serve. Such a recalibrated materiality standard would allow a meritorious claim to proceed while protecting companies from liability for good faith. The last component is empirical evidence from Japan shows that resource constraints are not a technical problem, they are structural one. An enforcement agency with fewer than 100 dedicated disclosure reviewers cannot effectively police 4,000 listed companies. This is not a criticism of the Japanese approach. It is a recognition that the task requires appropriate resources. Expanding public enforcement capacity serves as a function private economism cannot. The public authorities can enforce disclosure relevant to stakeholders other than investors and conduct systematic proactive review rather than reactive enforcement, and develop the sectoral expertise E&S information that private litigant and assurance providers currently lack, operate from a broader mandate than a securities market regulation, environment, and social interests. The cost of public enforcement is borne by taxpayers, and this, I argue, is normatively appropriately where ESG disclosures serve public interest beyond investor protection. So these three components mutually reinforcing. And this, I'd like to skip this slide. So now this is actually I'm now I am in the middle of studying the Australian approach. So this is my summarize of the Australian law. But for scholars like me, not familiar with the Australian corporate law, there are many difficult areas, such as the relationship between ASIC and the ACC, the division of the law between ASIC and the ACC, and the relationship between misstatement claims under the Corporations Act and those ASIC Act, understanding of non-shareholder stakeholder like NGOs in litigation. So I am still working to fully grasp these complexities. But based on my understanding, Australian law aligns remarkably well with the hybrid model I've presented today, making it a truly fascinating jurisdiction for my research, specifically in the realm of the ex-ante and private right enforcement. Australia has followed the European Union model in mandating third-party assurance, but the scope of information covered is more targeted than in the EU, focusing specifically on data where verification is most effective. While this doesn't solve the underlying problem of shareholders, only one group of ESG beneficiaries bearing the cost of assurance, it does serve to mitigate those compliance costs. As for ex post and private enforcement, Australia not only has a class action system, but also sees litigation brought by non-shareholder stakeholders such as NGOs. This stands in stark contrast to other jurisdictions where litigation is expected to be driven primarily by investors. To manage this broad standing, while deterring frivolous lawsuits, private litigation regarding sustainability report under the corporate law is restricted until the 2027 fiscal year. In terms of ex post public enforcement, I see that both ASIC and ACC imposing civil penalties for greenwashing. My investigation is still ongoing, but Australia appears to have built a hybrid regulatory framework that effectively layers these different approaches. From the perspective of my paper's analytical framework, it is truly fascinating case today. And this is just takeaways, key findings. So, sorry, I take too to many hours. So yeah.
The perfect amount of
Yeah, yeah, yeah.
perfect amount of time.
Thanks so much. Did you go up one slide?
It's over for the question time.
Which one slide? You go up one to 13. This one. This is this slide try to explain based on the primary purpose of ESG disclosure. As I said, yeah, the purpose of ESG disclosure divided into three purposes: that to protect investors' investment decisions, and to enhance the corporate accountability, and improving the external pressure for the companies from the, for example, other stakeholders, NGOs, the consumers, the other trading companies. And
what is NGOs? Is it an NGO or a competitor?
not competitor, it's just some activists, economical, so
yeah, no, I understand.
Yeah.
Just wanted to check.
And each jurisdiction has a different primary purpose of the ESG disclosure. For example, in the United States, it's mainly focus on the investor protection. They don't think the stakeholder pressure from the mandating ESG disclosure. So that type of jurisdiction, the first best mechanism is ex post private for investor harm disclosure. But as I said, ex post private litigation is itself perfect. So we have to the supplement of the detects of ex post private litigation. It's a ex ante assurance and not price impactful, but still relevant information is need for public enforcement required. So this slide means this type of the table. And if that jurisdiction expect the ESG disclosure to enhance the corporate accountability, the first best mechanism is just enhanced disclosures target and targeted assurance. Current Australia and Japan is relatively similar to this second part of the corporate accountability positions. Of course, I understand Australian securities is not technically it's different, but the securities law focus on single materiality, but try to enhance the corporate governance of the ESG. So I posit Japan and corporate and Australia is a second type of corporate accountability, and the last one is mainly European Union. European Union has relatively weak ex post private enforcement mechanism comparing with the United States, Australia. So they need maybe ex post public enforcement only after with mandate coverage, and the consumer or NGO enforcement is some supplement of this mechanism. So I try to explain of this table. Sorry, skip it.
And so your table, I guess, has underlying different theories of the corporation.
Exactly.
Yeah.
So maybe the last one, stakeholder society, or the pressure from the stakeholder is very close to double materiality and the stakeholder purpose reason. But the first one is very close to the shareholder primacy.
Pure law and economics.
Yeah, exactly.
And corporate accountability.
Yeah.
Corporation, having its own interests.
Exactly.
As an entity. Yeah.
But as best I know, as far as I know, Japan and Australia is not the first one, and try to balance the correct balance between the shareholder primacy and the stakeholderism.